Justin, what are the implications of a work for hire provision which is sent to an employee versus that of an independent contractor?
Sure. So I guess first let's back up. So work for hire is it's a legal doctrine in the US. The typical rule is that if I create something, I own it. The work for hire legal doctrine says, okay, if you're an employee that's doing something within the scope of your employment for your employer, it skips you. Like you create something, but it actually is though your employer created it. So it's like you weren't even in. I hate to say it that way, but it's like you weren't even involved. So it vests in the employer, and that creates some interesting things because when you go to register it, the company registers it, as opposed to in a normal situation, the author would be on the application and have an assignment to somebody. And so it changes the roles. So then back to your question, we see this language all the time, but there's actually a difference. So for employees, if they're creating work within the scope of their employment, that's deemed work for hire. Now we always paper it up to make sure, because there's always this question of whether or not they were within the scope of their employment. So then we always want to have these agreements to make sure that it happens. With independent contractors, however, it's the opposite rule. With independent contractors, it's the normal rule that if I create something and I'm an independent contractor, I own it. And the only way it can be assigned is by a written document that says that the copyright is assigned. And so without that, there's no transfer. And technically in the statute, even when you have that written agreement, there's like a bunch of categories for independent contractors, so if it's part of a collective work, which is, a bunch of people working on a project, then it can be a work for hire. Or if it's part of a multimedia or an audiovisual project, that kind of thing. There are a bunch of others, but those are the ones that come up the most. Then it qualifies for work for hire. So you'll typically see these provisions that say, hey, this is a work for hire, but just in case it isn't, like you hereby assign. And that's why they're doing that, is because you want the work for hire because it's better for the employer, but as a fallback, you definitely want the assignment. You don't want just the work for hire to fail.
And just so we're all clear here, why should employers even have these work for hire provisions?
Yeah. So, if you're a startup or even a big company, what you want is to make sure that whatever it is you're creating, if you're a software company, you want to make sure that you own your software. And if you don't have work for hire and or assignment provisions in all of your agreements, that means that somebody else could possibly own some of your software. And investors don't like that. Like nobody likes that, because it creates headaches when those people show up later and say, hey, you know what? I don't think I ever assigned my interest to you. And now this company is worth $1 billion and, I'd like a check.